evening, everyone. It is now just about 5 o'clock, and I'm ready to start my first webinar in about 4 or 5 months. We're back at it, starting our fall series and into the winter. We'll be doing probably live webinars once a month, although I'm now in the process of organizing some in-person seminars to go through the winter now that we're feeling a lot more comfortable about being past the COVID problem. And we, of course, have had hundreds and hundreds of clients in person here. So I'm hoping to get to the point where we're comfortable putting groups of people in the office. I feel strongly that the interaction between myself and potential clients and people at the seminar, direct interaction, questions and answers is really, really important. It's also much more enjoyable for me and for them because it is boring for me to sit here and talk to a camera and hope that you're home paying attention and thinking about this stuff. I can only guess since I can't see your faces, and I can't always figure out how to get the questions working. So that's my problem, is that because of my lack of skill in the technology, I'm not able to interact and answer questions while we're doing this. Nor is it easy as I'm doing my little presentation. So first, as you know, my name is Rob Hilton. Hilton Estate and Outlaw Law is my office. We do concentrate mostly in estate planning, wills, trusts, powers of attorney, healthcare proxies. We do some will contests, will litigation, estate litigation, and guardianships. And that's principally all we do. There's a certain element of real estate that is part of the business, as well as some corporation formation, corporations and LLCs as part of our estate planning and business succession planning. So today, of course, since it is basically day one, we're going to be talking about the basics. Always go back to the basics. The basics are critically important. I will hit on a number of topics today. My outline includes the very basics, some of the blended family basics, some of the unmarried couple basics. Then I'll get into trusts and a couple of different kinds of trusts and where they might play a role in your estate plan. Try to hit on as many of the important factors. The goal today is to get you enough information that you can then consider taking the next step. It's not going to answer all your questions. I understand that. And the goal is to give you some broad-based information and understand really how important this stuff is. Estate planning, of course, this is what we do, but we think it's really, really important. If you have someone who passes without an estate plan, you'll find out as I get into particularly the blended families and unmarried couples, how important or how problematic it can be if we don't have those things in place. So let me start with the basics. These never get old. They're so very, very important. So let me talk about the first one, and that is your basic will. That's a poorly written W, but that is a will. I hope you can see the screen or you can see my whiteboard. It's very important. I use the whiteboard frequently to write on for my discussion. So the will is the document that tells the world how your assets will pass from you to the people you care about at your death. All right? I think we've all heard of the term last will and testament. What does the will require, however? Most people don't understand, because when they talk to me about this, they say, well, we don't need probate because we have a will. That's incorrect. A will equals probate. So it means that if you have a will, in order to effectuate that will, it would be probated in what's called the surrogates court. Each county in New York has its own court. Oneida County has the surrogates court, but headed up by Judge Gelati. His job is to ensure that the wills that are submitted for probate are processed properly and that those people who are to receive under the will do in fact receive timely and receive the appropriate distribution. Okay? The probate process takes at least 7 months from date of appointment to closure. Most of the time probate is closer to a year to 18 months. Any longer than that, that probably means there's a serious concern or something holding it up, like real estate being sold or something. But the will, very important. It must be witnessed by at least 2 people. And then the 2 people who witnessed must sign an affidavit saying that they did attend the signing and that they did witness the person sign, and that has to be notarized. So that's called an affidavit of attesting witnesses. The will is critically important, and again, I will get into why it's so important, particularly with respect to blended families and unmarried couples. I can't express to you how important it becomes in those circumstances, but I think you'll understand it when I get there. So the will, basic number 1, everybody should have a will. If you're over 25, if you're married, if you have children, any of those things means you should have a will. Because what people don't understand is if you don't have a will, New York State has a plan for you. And that plan may not be the same plan that you want. For instance, in New York, if you don't have a will, your assets do not automatically get transferred to your spouse. What happens is the assets pass first $50,000 to spouse, and then half to the surviving spouse of the remainder, half of the remainder to surviving children. So if your intent is that all your assets pass to your spouse and you don't have a will, you may find that that is a problem. So again, really important that you have a will, even if you're married, or especially if you're married, okay? So the will equals probate. Probate's a process, requires an application to the court called a petition. It requires a death certificate, it requires a filing fee, it requires the will and the affidavit of attesting witnesses. And it does require, most importantly, waivers from all of the distributees to allow the executor to proceed in the court. Distributees are those people who would inherit if someone had died without a will. So in most cases, it's the spouse and the children. And they all must sign off. And if they're minors, then we have to have an attorney appointed for them to represent them in court, and that costs money too. So, okay, very important that you understand the will. Now, second most important, or arguably, I would say the most important basic, is the power of attorney, also known as the POA, power of attorney. Now, this document is where you appoint an individual or several individuals to act as though they are you. They are to make legal and financial decisions for you on your behalf while you're still alive, but you are incapacitated. This is critically important because unlike a will where New York State has a plan for you, New York State does not have a plan for you, or certainly not an easy plan for you, if you do not have a power of attorney appointed. So this is critical. So it appoints someone to make legal and financial decisions. Critically understanding you are alive. Okay? You're not dead. The will takes over when you're dead. The power of attorney is in control while you're alive. That's really important. Now, it is my learned opinion, I believe, that all powers of attorney should have a gift section. So what does that mean? New York State has the option on its power of attorney to initial a section that says, I authorize my agent to transfer assets out of my name, to make gifts. I call it transferring because in my world, it's really about moving assets from one person to another. Most importantly, from one spouse to another, but oftentimes it's to an individual to their children or an individual to a trust. Well, why is that important? Because when people come to me and say, hey, my mom or dad's going into a nursing home and I want to try to protect some of these assets, I can't protect anything if I can't move them out of their names. I can't move them out of their names if they don't have a power of attorney, and I certainly can't do it if they don't have a power of attorney with the gifting provision in it. So it's critically important that in the power of attorney, we have the gifting section filled out. In addition, there are modifications that New York State allows the attorneys to add, and those must be filled in. They must include the ability to transfer assets, the ability to create trusts, the ability to gift, the ability to transfer to oneself. All of these things are really important. So the power of attorney is predominantly a form that's created by the state of New York. However, the additional portions and the understanding of what must be included on that power of attorney are really oriented towards an attorney. And going on the internet, printing your own power of attorney and trying to sign it without guidance is problematic. It could cause serious repercussions if it's signed, doesn't have this stuff, and the person becomes incapacitated and now cannot sign a new one. Because what happens at that point is you are forced to do this. Guardianship. So where a power of attorney might cost you $500, a guardianship might cost you $5,000. And that is also a court process where you go into court and ask a judge to appoint you as your parent's guardian and effectively become a court supervised power of attorney. Instead of acting on your own without supervision, a guardian acts with court supervision, and you must ask the court anytime you really want to do anything very specific. This is not the route you want to take, trust me. So power of attorney, and a good one. Really critically important. I always like to say during these webinars, if you take nothing else from me today, take from me the fact that you need a power of attorney and it must be a good one. Okay? All right. Let's talk about the last third of basic, which is the healthcare process. Now, this is where I know people would be asking me questions, but of course, I don't know how to find questions on here. So that is a problem for me. I'm looking to see if I can find how the questions are asked, and I cannot. I apologize. Interactivity. Okay. Questions. All right. I don't know how to do it. See? I had to do this stuff while I'm not doing it live. That would be much better. Okay, healthcare proxy. Healthcare proxy is where you appoint someone to make healthcare decisions for you. Now, the healthcare decisions do not take place by its own terms until you are incapacitated and unable to make your own decisions. So that should put your mind at ease. Someone can't come in and decide, well, you're going to have, Mom, you're going to have surgery even though you don't want it because I'm the healthcare proxy. I'm going to make you do it. It doesn't work that way. So you must be unable to make own decisions, okay? That's important. And a good healthcare proxy should have some guidance about end of life, right? So how do you wish to be treated at the end of life? Do you want to have life-sustaining treatment for an extended period of time, or do you want that reduced or eliminated? Do you want to have, and some of this stuff comes by way of conversation with your loved ones and your relatives and your agents, but do you want to have them perform surgery? Do you want them to administer certain kinds of medicines or pain-relieving medicines? All of those things. Those things should be on the power of attorney, or on the healthcare proxy, so that the agent understands what it is you want to do. We also put on there, how about organ donation wishes? And how do you wish to be treated after your death? Cremation or burial? We'll even put on, in certain circumstances where we can identify ahead of time there might be a concern, who will be in charge of your remains. There is a legal provision, section 4001. I forget what it's called, but there's a provision that you can appoint someone to be in charge of your remains. So in case there's a fight between family members as to whether or not you want to be cremated or buried, where, how, you can put someone in charge. I certainly think it's important that you either write it down, pre-plan it with a funeral director, or discuss it with your family as to how you wish to be treated. This is not something you want your family fighting about. They're going to fight enough about money. Why should they fight about how you wish to be treated when you die, when you can certainly make those decisions before you're gone? Okay? So the healthcare proxy, Very important that it is well written, that it has your wishes on it, your guidance to your family, your guidance to your agents, and some guidance that the agent can provide to the doctor as to how you wish to be treated, kept alive, not, etc. So, three basics, three elemental basics in estate planning are the will, the healthcare proxy, and the power of attorney. Okay, they should be written well. They should, person drafting them should understand these elements, and they should understand how these work with respect to your family. A couple of things on the will. I want to jump back to the will now because I want to talk more about how the wills work. Okay, so this is a will. Now, in its most basic form, a will transfer assets, right? So I leave everything to my spouse. That's great. I leave everything to my spouse gets everything when I die. In most cases, the two spouses, this is the spouse, most of the assets are either jointly held, right? The house, the money, the investments, or the IRAs or life insurance are designated to the spouse already. So that when the first spouse dies, the will doesn't really activate and the surviving spouse inherits most everything directly. That's not always the case. A lot of times it is. But we want the will to read simply give it to my spouse if that's the issue. When I get into blended families in a minute, you'll understand the difference here. Now, here's where it becomes critically important. If you have young children, or for those of you who have young children, this will should then go on to the next step and create trusts for the young children. Because young people are stupid by nature, right? We do not want young people to inherit money without the benefit of having a trust and some guidance by someone that you appoint as a trustee to manage those funds and distribute those funds as they see fit. Because unfortunately, children that are 16, 17 cannot manage their own funds, and by law, they can't even own their own funds. When they turn 18, New York State says, yes, you can own your own money at 18. It seems to be a loaded question, but does anyone know a smart 18-year-old, right? Do we know any 18-year-olds that should be managing their own money? Generally, no, right? They're growing up, they're getting out of high school, some are adventuring to college, some are not, but they're in a position in their life where most 18-year-olds shouldn't be managing money. So what do? We put this in trust till they're 25 or 30. Part of that depends on how much money it is. Part of it depends on how old the kids are when you pass. Part of it depends on how mature you believe they are. Nevertheless, it is really important that we provide a little bit of guidance for these children prior to them inheriting this money. I believe it's really important for young people to understand what it means to have money. So what do I mean by that? Well, if they have a trust with $200,000 in it, and they know it's there, and they know they can ask for it, but they're tempered by the trustee, they will learn over the period of time up until whatever age you provided, how to act with respect to that money, how not to indulge themselves too much with respect to that money. And ideally, when they turn the age where the money is turned over to them, they've already become responsible with respect to that money. We hope that happens. It's not going to happen in every case, but that's part of the idea of extending the time frame beyond the 18-year-old point where New York State says it's okay to have money. So we want to create a trust so that the funds go in and that they don't get it till they're 25 or 30, okay? Whatever age you think is appropriate. Part two of this is really making sure that the funds that you own get into these trusts. So as I tell people when I talk to young people about this stuff, who are the beneficiaries of your life insurance? Because it's really important, obviously, if you have young children, to have life insurance. By the way, I should mention that if I do have any young parents listening or parents of young children listening, quick, simple metric for life insurance. First of all, it's critically important. Number two, if you want a metric, 10 times your salary. Now, it can go more than that and go less than that, but if you want a simple metric, 10 times your salary is a basic place to start. So, if you have life insurance and your beneficiary is your spouse, that's fine. Here's where it starts to break down. Who is your contingent beneficiary? Because it should not be, so it should not be, right, your children, if they're minors. It should not be your siblings. It should not be your parents. It should not be your best friend. It should not be your neighbor. It should not be your postman. It should be none of those. It should be either your estate, so it goes in these trusts, or directly to these trusts, so that the money goes here for your children. Now we have court-ordered supervision of the trustee to manage the money for your children, as opposed to leaving it to any of these people who have no obligation to provide for your children and no supervision. Okay? Really important that it gets to the right spot so it gets to the right children. Not to mention the fact that what happens if one of these people dies, where does it go? To their children or to their sibling? Okay? So the concept of funding, and that is the flow of the money. Where does the money and the assets flow? How do they flow to get into these trusts is so critically important, I can't tell you. So if you meet with an attorney and talk about your will, and none of the conversations about your money, your life insurance, your IRAs, any of this stuff comes up as part of the discussion, you know you've got a problem. Because it is absolutely vital that this part, the funding, the money part, is understood. Because if you just do a will and there's no understanding of the funds and how the money flows, the will may not, or very likely won't work properly. And that is really, really important, particularly if you have minor children. Or, I didn't mention this yet, what if you've got a child who's disabled? Okay? How important is it that you provide properly for a disabled child using what's called a special needs trust inside your will? Okay? So, if you've got a disabled child, and part of your plan is to provide for them, you need to be sure that this is set up properly, funded properly, and discussed properly. It's got to be part of the discussion. If you have a disabled child and you talk to an attorney and they don't even raise the issue, hey, what are we going to do with this child? You've got a serious concern and you need to move on. You got to talk about this stuff. Okay? So again, these are will basics. I'm still talking about basics. I'm not talking about anything crazy here. All right, let me move on. I'm going to move quick today. I've got a lot of ground to cover. I'm talking about concepts, things to think about. My goal is to get your mind moving relative to your personal situation. So what you need to do today is pick up on these little things that are relevant to you and say, hey, that's important to me. I need to talk to him more about that. Or I need to send him an email and ask him questions about that. Those are important things. I'm not going to give you complete solutions to your situation in this environment, okay? It's meant for you to pick up on some really important things. So the next one I want to talk about is blended families. Blended families, right? So we got husband and wife, and let's say in this case they each have 2 children. So we're going to give them each 2 children. Now, when I have a conversation with husbands and wives, parents, about what's important to them, I always start with a simple conversation. Listen, you guys have your own children. You have yours, you have yours. Don't lie to me and tell me that your children aren't more important to you than your stepchildren, because I'm not going to listen to it. Everybody knows that your children are more important than your stepchildren, period. Okay? That being said, it doesn't mean that your stepchildren aren't important to you. Let's understand that. And I do have people who treat children and stepchildren equally. That's fine. But what we have to understand is there's a process to make sure this works properly. And we have to, when I have conversations with blended families, which of course are frequent now, right? What's the divorce rate? 42, 48%. We got to have the conversation. So here's what we talk about. When I've got a husband and wife with separate children, and we have to deal with this concept, one of the things I talk about is using life insurance or IRAs to fund the first deceased parent's gift to their children. And why is that? Let's use an example. Husband dies. I always kill the husband first. Don't take it. It's not anything more specific than it's easy to do, right? Husband leaves everything to wife. Wife now has everything. She's got all the money. Now, each of them put in their wills, we're going to leave everything, if we both die, to our 4 children equally, right? Wife, of course, the week after the husband dies, and she probably wouldn't, and this cuts both ways, so just don't get offended. Week after husband dies, she has a falling out with her stepchildren and decides she's going to change her will, leave everything to her children. 2 years later, she could change her will and leave everything to her children. 3 years later, it doesn't matter. She could get remarried and leave everything to her children. This stuff happens. It's real, and to ignore it is folly. So here's what we do. I ask this to both spouses. It's not particular to either husband nor wife. I ask both spouses, buy a life insurance policy that's going to be your gift to your children. This is a great opportunity. Or if you have a big one, let's say you have $1 million policy, 10 times your salary. We're going to leave 20% to each of your children, right? 20%, 20%. We're going to leave 60% to the spouse. That's your gift to your children. If the surviving spouse leaves nothing to the deceased spouse's children in the future, you've done your part. And then I can say we did our piece to leave the first set of children something when the first spouse dies. Okay? Is it perfect? No. Is it even? Probably not. Is it something? Yes. And the idea is that we're going to provide an inheritance and try to mitigate the complicating factors later, like, oh, it was my dad's house, it was my mom's house, or this or that. So it has to be a conversation. It has to be understood by both the parties, and we have to come up with a solution to provide for this. Sometimes if the kids are older, we'll use IRA money to do it. So life insurance, IRAs, two good ways to provide in a blended family situation. Again, is it perfect? No, we can use trusts. But in this case, I'm just talking about young people with blended families, with multiple children, and complicated situations, and how do we try to remedy that? But we always start with a conversation, because if you don't start with that, you're never going to get to the end point. Okay, so a little bit about blended families. All right, so now we're going to talk about unmarried couples. Now, this is where things are really important. This is where you must have an estate plan of some kind that you've written, signed, and can be probated or utilized, whether it's a trust or a will. Why is that? Because in an unmarried couple situation in the state of New York, your significant other, your partner, whatever you want to call it, will receive nothing under the law from your estate. Now, they might receive things that you leave directly, life insurance, IRAs, things like that. But if you have a house, for instance, if you own a business, this has happened to me before. Forgot to leave the business to my significant other who also worked in the business and was going to run the business. We need to be clear about this stuff. It needs to be in writing. So if you are sitting on the couch right now and you're in an unmarried relationship and you're looking at your partner saying, oh my God, we have this stuff. You know, we have to make sure that we understand how this stuff is going to travel. For instance, sometimes second marriages or unmarried couples, the house is in one person's name, right? I bought it before we got together. We're not married, so I'm keeping it in my name. If this person dies, and particularly if they have children, this person's going to get nothing, and they're not going to have a house to live in, and that's going to be a problem. So using either a trust so that the significant other, the partner, is provided with a place to live until they die or something else occurs. There's a bunch of triggering events. Or that they have life use of the house, which is less than optimal, but is an option. Then we know that this ultimately, well, that we have a place to live for the surviving partner, but also that this house will eventually end up with this person's children or loved ones or family or whatever. This is a plan, again, really important that this one be written, because the surviving partner has no legal rights. Sorry about that. And as a result, when having no legal rights, we need to be sure this stuff's put in place. Okay? All right. So, again, we have the blended or the unmarried couple situation. Really important that this stuff's in writing and that everything is laid out very clearly and that things are provided for the surviving partner. We do not have stuff in writing with an unmarried couple. This includes same-sex partners. If they're married, it's different, but some same-sex couples are not. All this stuff needs to be spelled out clearly. Again, this is not utilizing a trust. I'm not talking about living trust yet. This is keeping it simple by using a will-based plan. It's got to be written. It should be good. Okay? All right. Now, again, today's concepts are basics. So, as I said, I'm covering a lot of ground, the different basics, to make sure that I've covered a lot of different things. Again, looking for you to find something that might be relevant to your life that you might want to hear more about. Just trying to make sure no one's sending me a text message saying they're watching me and that they can't hear me or something. I hope that's not the case. So, all right, now, next, I'm going to turn to trust basics. Okay, so there are a couple kinds of trusts. I'm going to start with the first one and why you might use this trust. This is a revocable living trust. So I draw it as an open box. This is our open box concept. The reason it's open is because in a revocable trust, you can put anything in it and take anything out anytime you want. You have a series of rules in here that tell us how the assets are managed while you're alive and how the assets will be distributed when you die. When would we want to use a revocable trust? What are the reasons you'd want one? Well, if you have people that you want to disinherit. So, disinherit children. Okay? That's one reason you'd want to use a trust. It avoids probate. It does not bring the disinherited children into the conversation. They are not available. This is not provided to them or available to them, and therefore they have no notice and no idea of what's going on. If you pass your assets through a will, even if you disinherit your children, as I explained earlier, if they are distributees, they will be put on notice, and they have an opportunity to come into court and object to the will. This is much harder. Number two, you own real estate in multiple states. So you might be a snowbird. You might have property in New York, and you might have property in Florida, South Carolina, Arizona. If you own real estate in multiple states, and you die with real estate in multiple states, in your name, you're looking at probating your will in multiple states. So you're looking at paying for probate here, then going to that other state and paying for probate there. Twice as expensive, unnecessary, because you could easily put this in the trust for less cost, manage it much easier, make it much easier on your children. Less interference with multiple attorneys in multiple states. So a real reason to use a revocable trust is real estate in multiple states. What else? How about we don't know your family? I know it's weird to think that, but I do have people whose some of their closest living relatives are first and second cousins, and some of them are all over the country. Some of them are in other countries. And avoiding having to deal with the closest living relatives who are cousins instead of the people you care about who might be significant others, partners, who might be friends or charities. We want to keep this out of the probate process so we don't have to find your closest living relatives. Very good reason for that. Taxes, right? Taxes. So for my wealthy clients, and wealthy could be anywhere from, for tax purposes, $6 million and up, if they're married. We want to use a trust to maximize the tax exemptions and minimize the costs in the process after someone dies. So it's a really good way to manage the estate tax issues for a deceased or for a family, husband and wife, particularly those over $6 million. But also, if you've got $2, $3, $4, $5 million, and you just don't want the burdens of probate with that much money, it's a good way to avoid probate. So just probate in general. Sometimes you just don't want to deal with it, particularly if your kids live out of state. It's a little more burdensome if your kids live all over the country. With the trust, we're doing a lot of our trust administration process via Zoom now with kids all over the country. It is a lot easier. A lot of it's paperwork, and we don't have to go to court. And we don't have to find people we don't want to find. Last one, at least for today, is a big one, and that's business transfer. Business transfer and continuation. So if you've got a business, you're the president and the sole shareholder, and you die, your business could be frozen. And that's certainly detrimental to any ongoing business. If you don't have things set up so people can write checks or the business can continue after your death with little interruption, you've got a problem. So utilizing a trust to own the business, particularly certain kinds of businesses, but LLCs are great, helps the continuation of your business with little interruption, and makes the process of moving it from one family member to another much easier. So for those 6 reasons or so, and there's more, there's certainly more, but those are the 6 best reasons to create a trust and utilize a revocable trust. Now the trust, which I'll explain more with the irrevocable trust, let me talk about what happens on the tax side. Just give you a brief rundown of taxes. I don't want to run out of time because I do want about 10 minutes to talk about the last piece. But with a revocable trust, if you've got a tax situation, when the first spouse dies, let's say there's $7 million in this trust, and the first spouse dies, we take $6 million and put it in what's called a family trust or a credit shelter trust, and then we put $1 million in what's called a marital trust. And that means that even though the tax exemption is only $6 million, this person is going to pay 0 tax even though they have $7 million, because this million over here will pass through their spouse's estate, and the spouse will not have to pay taxes until that spouse dies. I know I'm doing it very quick and I'm doing it very basic, but again, if you're a family with more than $6 million and you want to talk about taxes, really, really important to consider how your estate is split up to ensure that at your respective deaths, you've managed the tax problem. I do have a client who's got a lot of money. Spouse died with no exemption. He inherited everything, and now he's got a serious tax problem, because he didn't do any of this stuff. And it was an unfortunate error, and that error is going to cost him a couple $1 million. And that's a problem, and he's not too happy about it, but this happens. And so really paying attention to your estate, the size of your estate, and making sure that you have plans if you've got a taxable situation is, again, critically important. If you're over 24 million, that's when the federal exemption kicks in. A married couple over 24, which, by the way, is due to go back to 5 million in 2025. These issues need to be addressed. And I know it sounds like, well, who's got 24 million? Well, believe me, more people than you think. And so this is a really serious discussion, because the tax implications, if you're over 24 million, are staggering when you start talking about the federal cost. Federal tax is 40%. New York State's only 5%. Still a lot of money, trust me. But once you get to the federal level, it goes up exponentially, and you really need to deal with how to manage your estate and how to manage the taxes for your estate. Okay, so important things. Let me just talk about the last piece. It's going to take me 10 minutes or so, and this is really what most of the people, when they come and see me, they want to talk about, and that is, how do we protect our assets in case we go into a nursing home? What's this 5-year thing? How do we do this? It's it's important to understand the basics. I think it's important to consider how and when you should plan and how far ahead of time you should plan. And whether it's important to you is really up to you, but you should know the basics and not be afraid of the rules and not be afraid to sit down and talk about this stuff. Okay? So let me explain basic number one on asset protection. Let's call it asset protection. If you want to protect your assets, you need to not own them. That's just a simple basic element. You can protect your assets if they're sitting in your name and your ownership. So what does that mean? Do you give them away? Well, sort of. One option is to give your stuff away. Give it to your kids, do what you want. That is not a great option. For a lot of reasons, tax reasons, fundamental estate planning reasons, you might need the stuff. For all these reasons, we don't like to give things away. So what do? Of course, we use a trust. So a trust, and the right kind of trust, allows us to join two important concepts. Number one, giving your stuff away, but retaining control of that stuff. So how does that work? So for those of you who can see that and understand what that is a poor drawing of a safe. And that safe is my irrevocable trust. This is a Medicaid trust, which is significantly different than an irrevocable trust you might look up and find on the internet. So be very careful when you're doing your own personal research and running the stuff down on the internet saying, oh, I saw an irrevocable trust and you can't do this, and you don't get this tax benefit or that. Follow me on this first and understand how this one works. This is a significantly different trust than a tax planning kind of irrevocable trust. So first of all, what do we put in here? Well, we're going to put your house in there. We're going to put your second home in there. We're going to put your life insurance in here. We're going to put some investments in here. We might put an annuity in there. We might put some cash in. Okay? Now, there's some very important rules that you must follow. Number one rule, whatever we put in here, the rule is we can't take it out and give it back to you. That's a no-no. We certainly can't take principal out of it. We can reserve the right to income if we want. So we can have income available to you from that trust. What is income? Income is interest and dividends and rent if you have a rent situation. So you may have let's say you've got a house in Florida and you rent it out 6 months a year. That money can come out and go into your pocket. Okay? Now, what are the other rules? Number one, very good rule, you can be the trustee. Now, there's no law preventing you from being the trustee and controlling everything. Some attorneys don't like it. I can tell you that there is no rule preventing you from being a trustee, not this kind of trust. That rule applies to tax trusts. You can't have an indicia of ownership by being a trustee in a tax trust. This is not a tax trust. Everything in this trust is going to be includable in your estate when you die. They're not trying to get it out of your estate. That's a whole different element. This, you can be trustee, which means you can control everything that proceeds and goes on and occurs inside that trust. For instance, you want to sell this house and buy a new one. You want to use this money to put a roof on this house. You can do that. You control everything. You don't have to ask permission for it. Okay, like it or not, those are the rules. Now, if it's in here for 5 years, you get 100% protection from nursing home. That is still the rule in New York State. That's the rule actually federally. So 5 years, 100% protection from nursing home. If you need something out of this trust, let's say there's something in there you want, the trust can make distributions to your beneficiaries, who are most often your children. So the trust is authorized to make distributions to your children. The children then can in turn do what they want with that money. They can spend it on you if they want. They can give it back to you. There's no prohibition. You can't force them to. But of course, if your children like you, I hope they will give it back to you. Okay? Now, let's talk about what can't go in the trust. IRAs, 401ks, 403bs, TSAs, TSPs, any qualified or untaxed money cannot go in the trust. The good news is those funds are ostensibly or mostly protected from nursing home costs, because those monies are considered income rather than a resource, and so they only fall into the income category if you go into a nursing home. Number two is your fixed income. Whatever you earn on a monthly basis, whether it be pension, Social Security, or otherwise, including your IRA distributions, those are not in the trust. Those come to you, and you're using those funds to live on. And finally, of course, we have the all-important, what I call the mad money category. The mad money is the non-qualified assets that we keep aside for you to have fun with and enjoy and use and have. And so for a married couple, generally speaking, if they have it, we put it around $100,000. Conceptually, we put everything else into the trust, and we get the 5-year clock started. Depending on their personal situation, depending on how much the fixed income is, we have to up or down that, raise or lower that mad money piece so that they have sufficient funds to live on. Each and every family is a different conversation. Each and every family has different circumstances, and we will talk about how and where this fits with your circumstance, okay? But that is how it works. Now, I want to talk, so I'm closing in on my last few minutes, about how, when you die, the assets are passed on in this trust to the people you care about. So what happens is this trust, let's say there's 3 children in this family. Mom and dad pass, the assets pass down to the children, and you see I drew little boxes, and those are meant to be boxes anyway. These boxes represent little trusts. These little trusts are there so that each of these children are protected from stuff. What is this stuff? I call it the 5 Ds. 5 Ds are divorce, disability, disease, death, and debt. So what we're trying to do when we leave assets behind to children, we want to be sure they're protected. You spent the time, effort, and money to protect your assets up at this level, in case you needed nursing home costs or got sued or something like that. We now pass it down to the children. Why would we not take that very next logical step and provide them with the kind of protection that you would want them to have? Particularly if there's a lot of money passing on, there's not only the 5 Ds, but there's also tax protection that is built into this. That means that these funds are not includable in their estate, so that when they die, they will not pay estate taxes on this money, particularly if there's a lot of money in there and they are themselves wealthy. So, protected from creditors. Now, let's say they don't have any of these 5 Ds going on, and they want access to the funds. They can take the money out. They can take some, or they can take all of it out. But they can enjoy the money that you've left them, assuming you give them the authorization to do that, and assuming they're not disabled. They can take the money out and enjoy it. If they are disabled, legally disabled, then that's a whole other issue. Requires a special needs trust. But other than that, if these people are not disabled, they have control of their own funds and they can do what they want. If one of these people dies and their assets pass down to their children, of course, once again, we put it in trust for the grandchildren, so they're 25 or 30, to ensure that they don't do anything stupid with it. Of course, there's no guarantee at 30 they won't do something stupid, but we hope by that time they've learned enough so that they won't be frivolous. Okay? So, asset protection. Basic asset protection, number 1, get it out of your name. Number 2, get it out of your name and still control it by putting it in a trust. That way you haven't given the money away and your kids won't spend it or get sued and have liens put on your house and things like that. By the way, for anyone who wants to know, we've written an article called The 9 Reasons You Don't Give Your House to Your Children. If anyone wants that, they can either go on the website or simply call us, we'll send it to you. very important. Do not give your house to your children. And if I'm not clear about it, do not give your house to your children. It is a bad idea. Do not give your house or your other real estate to part of your children. If you have 5 children and you only give it to 1 or 2 because you think they'll share it, that's a bad idea. What happens if they die, get sick, become disabled, get sued, get divorced? For all those reasons and many more, we don't want to give it to children. If you put it in the trust, when you sell your home, you will not pay capital gains because you have an exemption. If you give your house to your children and then you sell your house, they will have to pay capital gains tax on it. That's a bad idea. Okay? I had a family in recently. We did the math on the transfer and the calculation of how much it was going to cost them in capital gains just by mom and dad transferring the house to them. It was upwards of $30,000 to $40,000 in capital gains tax. Just the transfer. The attorney never told them about that. Puzzling that the attorney wouldn't mention that, right? Well, a lot of times they don't understand it. It's really, really important that if you're going to do things like that, utilize the trust. It doesn't have the tax implications. In addition, if you give away stuff like investments, houses, real estate, stuff like that, then what you won't get is you won't get the tax benefit when somebody dies. So if you haven't heard of this before, it's called the stepped up basis. If you own something, let's say, I'll give you the easiest example. Let's say you pay $1 for a stock and it's now worth $51 a share, right? That $50 is called capital gain. You will pay tax on that when you sell that stock. You could pay up to 25 and 30% on the sale of that stock in capital gain, depending on your income. If, however, under the current rules, you die owning this stock, then your family inherits it at this new basis. It's called a stepped up basis to $51. If they sell it the next day, they pay 0 tax. This is a critically important estate planning tool. It's a critically important tax planning tool. And you must understand where and when it applies to your assets so that you don't make the mistake of handing your assets over to someone and costing them thousands of dollars in taxes where they wouldn't have to pay thousands of dollars. Instead, you put it in the trust, wait till you pass, you get the stepped up basis, the kids pay no tax. Believe me, this is a strategy that should be used in a good estate plan, but sometimes is overlooked. So consider old legacy stock, things like that, that's been around for years, that has a low basis and a lot of tax built in. And how you manage that is important. Okay? Oops. So, this is the asset protection basics. So we covered today, in a mere 50 minutes, the basics of estate planning: will, healthcare, proxy, power of attorney. We talked about how we manage and fund a will. We talked about how we manage a blended family and how we manage that through distribution alternatives. We talked about unmarried couples and how important it is that having a written document and having a plan in place for unmarried couples, it's just critical, making sure that that stuff's in place and that when someone dies that's unmarried, that their wishes are carried out and spelled out in a will. We talked about the basics in revocable trusts and the 6 or 7 times we would use a revocable trust, very important reasons to use it: cost savings, tax savings, time savings, efficiency, all those reasons. And then we talked about the basics in irrevocable trust planning, what I call asset protection or Medicaid planning. And the basics here, the elements of this, why it's important, and how asset protection works. Number 1, getting assets out of your name, but number 2, still controlling them. It's really, really important. And likewise, taking advantage of the tax advantages of you still owning property when you sell it or when you die. Okay? So I hit on a lot of topics tonight in a very short period of time. My goal again today: issue spotting, issue providing, fact providing, a little bit of information. Pick up on those things that are important to you. Find out what you need to concentrate on and give me a call or email me with more questions. Obviously, part of my goal is to have clients invited to come in and see me and try to address their particular situation and resolve any questions you have to make sure that your individual situation is clarified and that any of your needs are met. Okay? For those who don't know, we provide a free initial consultation. There's absolutely no obligation. You come in, we go over your situation, we look at your assets, we look at your family, we have a discussion about how to do this, and I usually draw a picture, and invariably I give you a price on proposed plans, 1, 2, or 3 that day, to try to meet some or all of your goals. Okay? I'm happy to take emails. Even I answer a lot of phone calls, but emails are great when we're talking about these things. Really, if it's going to be a fact-based question like, what if I have this or what if I have that, and coming in and seeing me would really be the best way to do that. And you're certainly invited to come in. As I said, my hope is that we start up doing in-person seminars to really get a lot more question and answer and feedback, at which point I'm able to do a lot more getting involved in your personal questions at that point, although there will be other people in the room, so you just need to be cautious about what you share, okay? So, let me just put up my email. In case you don't have it, all this stuff's on the website. I'm not great at communicating via Facebook and all that stuff, although we do have some of that capability. I prefer direct emails. So, email rkh@hiltonlawny.com. Phone number 315-624-9600. Again, it's Rob Hilton. I was hoping to introduce everyone that was here to my new associate, John, but he is preparing his trip out of the country, and so he had to depart early, unfortunately. So maybe next time we'll get him on and get him to do some presentation or at least introduce himself. My hope is that if you come see me, you'll also get to meet him and spend some time with him. He's really learning this stuff very quickly, and we're happy to have him aboard. So that ends I'm at about 55 minutes. I went a little over. Again, I really wish I knew how to answer questions. Says no questions here. I guess I'm trying it. So what I'm going to do is probably end this, and this will be saved on the Facebook page, and invariably we move it over to the to our website as well, so that it can be viewed in the future. I was happy to have a client in today who told me they watched a couple of videos, so that was great. Anyway, I look forward to your questions. I look forward to seeing you. I thank everyone that came tonight, and wish you well.